Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business. You know, I love always having my friend Lee Kaplan on the program. He's a great asset to us, bringing insight, knowledge, and information. And recently I had him on the program where we talked about minority shareholder rights really being discriminated against in the state of Texas. And it inspired me to write an article about it over at Huffington Post. People try to pin me ideologically and, is he a conservative? It's certainly not a liberal, obviously. I like, and probably some think I'm libertarian, although I might be somewhat from a small L perspective, but I like to think I'm a consequentialist. I like to look at consequence. I really don't care about ideology. That's why I don't like term limits, even though other people do love term limits. I think it's a bad idea. I don't like vouchers because if you don't want government controlling things, why would you have them fund anything? Because I don't know what the government funds and doesn't ultimately control. Things like that. And so I looked at this issue of minority shareholder rights, and it really is an interesting thought and an important debate. And since, Lee, you inspired the article, why don't you set the stage for us? And before you do that, do you want to mention he is with a great law firm called Smizer, Kaplan, and Veselka, and you can learn more about them at skv.com. Lee, tell us about, set the stage for us.
Well, our firm basically handles commercial litigation and white-collar criminal matters of all sorts, but it's usually business disputes, both trials and arbitrations, as well as appeals.
Very good.
There are all kinds of disputes that come up in business, and frankly, in an uncertain economic climate, there seem to be more of them than there are in good times, just because people can't work things out. When times are harder, they're more likely to litigate.
Yeah, no question about it. Good times actually lead to less lawsuits. People can be more generous.
I think that's right.
Yeah, no question about it. Set the stage on this topic for us today.
Well, there is a case called Ritchie versus Roop or Rupee, R-I-T-C-H-I-E. It came out June 20th, I believe. And essentially, the Supreme Court surprised a lot of people by ruling 6-3 that minority shareholders do not have common law rights for what's called the minority shareholder oppression claim. This was a case in which there was a minority shareholder who wanted to have her shares bought back at some fair value or get the company bought out, and the trial court essentially ruled in her favor. The Court of Appeals did the same thing, ordering a buyout at a fair price. The Texas Supreme Court reversed, and it said that's not oppressive. And even if it is oppressive, there's nothing under a statute that orders courts to order a corporation to buy out a minority shareholder. And the court explicitly said we don't recognize a common law cause of action for minority shareholder oppression. And, quite candidly, over the years, I've handled some of these cases, and they're very appealing to juries in some cases that a minority shareholder shouldn't be squeezed out. So it really is going to affect the way people enter into business arrangements. The old situation where three people decide to enter a business and they're all going to be one-third owners and they think they're protected, that just doesn't necessarily apply. So now you have to write up the formation articles of the corporation, the bylaws, explicitly to protect a minority shareholder in the event one of the three, say, or any minority shareholder gets crosswise with the majority.
Mm-hmm. It seems to me now, based on this legislature, and now we've got a fiscal crisis. They're, of course, washing it off that there is a surplus, but how long is that going to last? They act like the oil situation is only going to be a year problem. It could be longer than that. They don't know. I would doubt with a legislature that meets every other year and the sentiments of this legislature, they're probably not likely to deal with this.
I think that's right. And people will perceive that this is a relatively small problem. Well, it may be, it may not be. There are many family-owned businesses where someone passes away and leaves their shares to a number of children, assuming the children will get along or they'll be protected. And now, if you've got 3 or 4 children in the business and one of them is upset or feels they're not being treated right, they do not have automatically the kind of protections that people might have assumed they had. And therefore, it really behooves everybody when they go into a business to make sure they've got legal advice on how to protect the minority in the event there's a falling out. Now, I'm probably arguing against my own self-interest because if people take those steps, they're less likely to have litigation later. Mm-hmm. But I would say that people, even small business people, should have legal advice when they form a business entity in which there will be minority shareholders.
Mm-hmm. Mm-hmm. So kind of give us an idea of some of those tasks that people should be taking.
Well, what you can do is write in buyout provisions, valuation or appraisal provisions. In other words, if a minority shareholder feels they're not being treated right, or everybody comes to a parting of the ways for whatever reason, then you can have what are called buy-sell agreements in which one side makes a bid and the other can either sell at that price or buy the whole company at that price. You can have appraisal rights in which when they have these problems, somebody goes out there and they agree on some neutral appraiser or a process for finding an appraiser who values the company. And then the minority shareholder is bought out at a proportionate value consistent with the overall value of the company, or perhaps a slight discount. But you can put these rights into the corporate bylaws and the formation documents for the corporation. The point is, you don't want to get to the point where you have this problem and discover that you don't have something written. In other words, there's no common law right, but you can create the contractual rights at the beginning. And you can do them later. I mean, people could say, we might have a problem someday down the road. Things have worked great so far, but let's amend our documents to make sure these rights exist, just in case.
Truly proving the idea of an ounce of prevention is better than a pound of cure, certainly in a case like this.
Absolutely.
All right. Again, Lee Kaplan, he's a regular contributor here on The Price of Business, does a phenomenal job. Great information and insight for us. You always got a great story for us. I planned today's show a little heavily because of the article at Huffington Post. I was very excited, always excited about that because of the awareness that raises on a topic. But you always bring great topics to us, and I appreciate it.
Well, I enjoyed it. Look forward to speaking with you next time.
You bet. All right, Lee Kaplan, learn more about him at skv.com. That's skv.com. You'll be able to see the article at Huffington Post at U.S. Daily Review this morning. In fact, go there right now to see the article we're talking about. More after this on The Price of Business.